Good morning. Are you Dakota Coon? And Mr. Lewis, will your client waive the formal reading of the motion?
He does, yeah.
Mr. Coon, in cause number 23, DCCR 0968, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 1st of 2024 for the lesser offense of attempted assault on a family member by impeding breath or circulation, state jail felony, and that was a 2-year deferred probation. Is that correct?
Sure.
And then count 1 alleges that you violated your probation. It alleges that you committed the new offense of possession of a controlled substance, May 12th of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you violated your probation by possessing a drug, cocaine, at the time of that arrest on May 12th in Chambers County. Is that true or not true?
True.
Count 3 alleges that you failed to never become intoxicated in that you provided a urine sample April 30th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample May 9th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 5 alleges that you provided a urine sample May 21st of 2025 that tested positive for cocaine. Is that true or not true?
True. Judge, that's enough.
Sure, the state abandoned 6, 7, and 8. Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Okay, and did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Coon is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of attempted assault on a family member by impeding breath or circulation. Sentence you in accordance with your agreement. Sorry, my tablet just got to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read that written admonishment to see what devices qualify as a firearm or ammunition. Also, if you have any questions about how long that lasts or any of those laws, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. I was going to try to shorten it. That didn't work. I need to write out what I want to say. I did it once right today, and that was it. Just too many words. I just want to make sure. Mr. Lewis, you've got Camden Jackson. There, I guess she's been looking for jail reports or anything on any of these. She hadn't handed me any. I don't know.
be any on Jackson.
Okay, my computer's stuck. Good morning, are you Camden Jackson?
No.
And this is 25 DCCR 0114. Mr. Jackson is charged with engaging in organized criminal activity. Mr. Lewis, what is the announcement?
Well, Judge, this is one that we reset from the last setting because he had not been getting his medication, was trying to get that taken care of. Shortly after the setting, he was able to get his medication and has been on his medication since. And since he's been on the medication, we don't have any jail write-ups or any issues of what we previously have been seeing before all this started.
Okay.
And
yeah, I remember. I did send an email, made a call about that. Okay.
right.
Okay, so where are we now?
Well, I've talked with the state about the situation, and we were in hopes that now since we've got this issue resolved with this medication, he can go ahead with the ISF condition, and so we can continue on. But that's what this whole came from, that he was, MTRP was
This
filed.
shows, sorry, it doesn't show MTRP on here.
Yeah.
Okay, sorry.
No, I'm sorry.
Okay, so,
Judge, if I may, I'd like Ms. Lopez to give her input. I think she has a little bit of a different opinion. Obviously, we all different in court, but I trust Ms. Lopez's opinion on this.
we haven't gone through the motion, gotten any pleas on the motion or anything like that.
No, we didn't do any of that.
Okay, Ms. Lopez, would you raise your right hand, please, ma'am? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thanks. So what's your position, I guess?
Well, Your Honor, I would like to point out just a couple things. Originally, this all transpired because he was sentenced to ISF and you had told him to get no further write-ups at the jail. He then received another write-up, and it was enough for you to ask Ms. Warner to specifically request that I file an MTRP. I received an email from her that stated that you specifically sent the report for it to be sent to me. And so that was why the MTRP was filed. Since then, we've had quite a few jail incident reports. I actually went and saw Mr. Jackson out of the jail in August 28th of 25, in which I informed him of the MTRP being filed, and I advised him, hey, you really need to behave while you're out here, because at this point you are going back in front of your judge. And then it continued. Now I understand that since he's been on his medication, he has not had any incidents. And so my request at this point would be that if the secret to Mr. Jackson behaving is medication, then I am still in favor of him going to ISF cognitive. However, I would suggest that he be placed on the mental health initiative caseload, forensic caseload afterwards, because if the only way Mr. Jackson is going to be able to...
This is a rare courtroom moment where everyone, the judge, prosecutor, and defense, align on one thing: mental health matters. But notice the balance here. The court isn't excusing behavior. It's demanding accountability with structure. Medication isn't a free pass. It's a condition. Do you think the system does enough here? Or is this still reactive instead of preventive?
to function and behave in society as with mental health meds, then he needs to be on the mental health caseload.
Absolutely.
Additionally, however, I would say that it needs to be established that he be on zero tolerance, because if he's acting like this at the jail, I don't need him acting like this in the community.
Agreed.
And then I would also truthfully suggest that once he completes the mental health caseload, he then come to the high medium risk caseload, because additionally, if he needs all this help in order to behave, he needs to have serious supervision long-term or longer term. That's not to say that he won't ever end up on a regular felony caseload, but if he's having this much trouble behaving in the jail, it tends to say that he needs a little more assistance.
I don't disagree with any of that. Do you, Mr. Lewis?
No, I don't, Judge. This was definitely a situation where, this is once I was appointed, of course, I had him evaluated for competency, and then to the point where when I realized that he hasn't been on any medication the entire time he's been in custody, that definitely stuck out to me. Just the fact that in this short time since he's been on his medication has made this difference, then definitely those issues for mental health issues need to be addressed to make sure that through probation he does get the help he needs, the proper vehicles for him to be successful.
What medication did they start, Mr. Jackson?
I really don't know.
You don't know what it's called?
I'm not good.
You take it every day? And when did that start?
It was about a week or two after the last court date.
Okay,
He was last here on January 6th.
That's what I thought.
Right.
okay. These are all, the last one that I show is from Christmas, December 25th. Okay, thank you. So then what I need to figure out then if, there's obviously a motion pending. So either we go through the motion and I continue him with these. I think I'd rather do that than just dismissing the motion with new conditions. I'd rather go ahead and go through the motion, get pleas of true on that. I'll agree to what everybody's saying, but I think I want to do it the more formal way.
Okay.
So let's go ahead and go through that motion. Mr. Anders, raise your right hand, please, sir, the best you can. Not Mr. Anders, I'm sorry,
Jackson.
Mr. Jackson. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. So let me get it pulled up here. And we never, so the ISF was just, we didn't go through any of this, please, ever. Okay, that was just part of the, that was an agreement with regard to admin hearing.
Correct.
Okay, all right, so,
One of the conditions of his probation order was that he
right,
have no further issues at the
so
jail.
we never even got,
And then before we could even do the paperwork to ISF, he had issues at the jail.
okay. So you haven't seen the light of day yet? You ready to? Okay, well, we're gonna give you the tools to do that, but it's gonna be up to you to take advantage of all that, okay? So you can see by what happened last week, if you ask and say, hey, I need something, then a lot of times people can help you. Y'all let me know that, I was able to contact the jail, things happen. So the important thing about all of this when you're on probation, whether you're in jail, whether you're at ISF, or when you get out, hopefully, if you're having things that aren't going right in whatever part of your life, your probation officer is going to be there to help you. They're not trying to revoke you. They're not trying to get you in trouble. They don't know if you need something unless you go to them, right? Okay. So I'm going to go through this motion and ask you for pleas of true or not true to the allegations in the motion. So in cause number 25, DCCR 0114, have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 5th of 2025 for the offense of engaging in organized criminal activity, and that was a 7-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to conduct yourself in a courteous and professional manner by disrespecting a female correctional officer by showing her a video that was lewd and sexual in nature. Is that true or not true?
True.
Okay. Count 2 alleges, count 2 is really the same. Okay. All right. So did you enter your plea of true to count 1 freely and voluntarily? And did you plead true because that's actually true? All right. And so, well, let me go through this and then we'll talk about some more. So I'm going to find count 1 true, find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. You are still ordered as a condition of the probation to enter and successfully complete the ISF program. When you're out, you will be on the mental health caseload so that you can get whatever help you need with medication, counseling, whatever it is. Once you get through that, you'll be on the high-medium caseload, which also means you're just going to have to be you're going to go more often. Probation's going to have more things to help you. It's not meant to be mean or make you go more than other people, but with what you're showing us so far, you need this extra help, okay? So if you do all of that, you're still on a deferred probation. You're still not a convicted felon. Today, just based on what I told you before about not getting in trouble, I could easily send you to prison for up to 20 years, just like that. And I understand that there's some behavioral issues going on, but I don't think any of those behavioral issues had anything to do with what you did to that correctional officer. Okay? The cutting up, maybe the not being quiet, the fighting, all that stuff, maybe there's some issues. But that was a conscious decision that doesn't have anything to do with any other type of mental illness or help that you need to go and show her that. It was just being stupid, right? So if you make a choice, that's a choice. That's not something that we're going to blame on anything else. I understand some of the other write-ups. That one, I don't buy that has anything to do with that, right? So if you do anything like that again, and you get in trouble, now that everything's lined out and you haven't been getting in trouble, if you do, before you go to ISF, we will not be having this conversation again. Okay? Same rule applies. It is a condition now of your probation that you not receive an incident report. If you do, we're back in here, and I don't care what anybody says, you're going to end up in prison. You've got family. Nobody wants this to happen, but it's 100% up to you at this point, okay? If you get to ISF and you don't follow the rules in ISF and get in trouble there, same thing. That's a condition of your probation, is that you act right in ISF as well, okay? All right, so anything else?
0 tolerance.
And you'll be on 0 tolerance, which means really everybody should be on 0 tolerance when they're on probation, but when you're actually on what we call 0 tolerance, it means you cannot make any mistakes. You're being given a huge opportunity to change your life, make better decisions, and it's just going to be up to you to do that. And if you don't, it's not going to be well, this is a one-time mess up, give me another opportunity. 0 tolerance means you don't get another opportunity, okay?
Yes, ma'am.
Why'd you just look at her like that right in front of me? Don't, no, ma'am. No one is against him today. Don't say another word or you're going to end up in trouble. No one's against you today. They're saving you from going to prison today, because that's what I was probably going to do. Because I gave you a specific instruction and you disregarded that instruction, and I don't think it has anything to do with mental illness that you're showing ladies videos that are inappropriate in the jail. Nobody made you do that. She didn't make you do that. I didn't make you do that. Do you understand? This is personal responsibility. It's time for you to take personal responsibility. And it's time for you to make him take personal responsibility and quit blaming other people for what he's doing. That's what just I heard. So just hang on. Don't talk anymore. It's not going to help anything. You're receiving a huge chance today. And it's because of probation that you're getting that opportunity. Okay? So you remember that. It's because of them that you're getting this opportunity. Okay? Go back with the bailiff. Roderick Anders, Mr. Lewis.
Roderick Andrews.
Are you switching sides?
No. I'm a special persecutor here.
Special emphasis on
Specialty. Better be careful, I might dismiss your case or something. Let me stand too close.
Good morning, sir. You Roderick Anders?
I am.
And Mr. Anders is charged in cause number 25 DCCR 0388 with aggravated assault with a deadly weapon. Case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, there's two things I wanted to definitely let the court know before making an announcement on this one. We had one little issue with discovery. There was some of the discovery that was hard to open where we had to get new copies. Mr. Coleman did provide me a new copy of that, which I believe was some body cams and a witness statement. So I do need to review it and go over it with my client.
I'm sorry to interrupt, Mr. Lewis,
No,
but
go
if I could respond to that specifically, Judge, that issue was an issue I brought to Mr. Lewis's attention in reviewing the videos, the set of videos that we have in this case, that I had trouble, and I asked Mr. Lewis if he had trouble opening those same videos, and I provided him with copies that would open. I just want
Okay.
the court to think we were kind of hiding.
Oh,
No,
yeah,
that's
no,
it.
no.
Yeah, and when did that
That
all?
was last
It was
week.
last week.
Okay.
Last week, and that's why I picked it up this morning. He had it ready for me. The other thing is, this case, we happened on the trial docket, he was originally on bond. There was an issue about his bond amount, where his bond it was set at 75,000, but it was put in the system at 7,500. And he bonded out and had been out on bond for a while, and then you took him into custody the same day.
Right.
And I believe it was his intention or the family's intention that they were going to was working to try to retain him another attorney to go forward. Unfortunately, his mother, she was on probation as well. She was sent to ISF a few days later, not long after. She'll be released Thursday, it's my understanding. She will be home. And so I know their intention will be to try to hire another attorney.
I can't leave it on the
I know.
trial, it's already
I-
been on the trial docket this time for give or take 3 months. And so what I'm going to do is I'll number the case. You have time this week to go out, go over all of the information with Mr. Anders. If something changed, I'll number the cases. I do
It's
have.
ready for trial by week.
Okay, I have a couple that are older, but that doesn't mean things
Right,
can't
I
fall
understand.
apart.
So, I mean, of course, I'll still prepare and everything, but I
Okay.
want the court to know.
I appreciate that, and just get out there, go over everything with Mr. Anders that you can. If something changes this week, based on you guys watching that you want to negotiate or something, then based on what you're telling me, I will allow there to be a plea after, which I normally don't do, but since you're just getting that, I think that's fair, Mr. Coleman. And so if something happens when you guys are watching that and there's some change and y'all negotiate, then we can get that taken care of next week. But I will do the numbering today, but I
Okay.
still want you to go ahead and go do all of
Oh, I
that.
will.
Okay,
right, thank
perfect.
you.
Thanks. You can go back with the bailiff. What? I thought my ears are red. Uh-huh. Oh, yeah, they are. I feel like all of it is. Say Elijah Miller, Mr. Lewis.
Judge,
Do we need him?
if we can maybe hold on him for a little bit, I know we were trying to confirm his credit.
Okay, I'll hold on that just for, take them back. I'll hold it while y'all can get that figured out. And then, on David Greer, Mr. Kimler,
Yes, ma'am.
2 cases.
Actually, it's 3.
Yeah, they're separate. Same reason, Judge.
Well, because 2 of them had Mr. Parker on them, I guess. Initially.
And the other one was just indicted last week, so that's why it may not show.
Oh,
The
I
printed
did, I can
document.
work on it. So,
all right, sir, you're David Greer. Speak up for me, please. Thank you. And will your client waive the formal reading of the indictment in each case?
so is.
Judge, on the state jail, the 26 cause number, may we proceed just on count 1, but with the 2 bullet points that make the misdemeanor at state jail.
Yes, ma'am.
No objection.
Thank you. Bless you. Okay. So, Mr. Greer, in cause number 26, DCCR 0150, you're charged, the state has elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of evading arrest or detention with previous conviction and that's from October 2nd of 2025. It alleges that you were previously convicted of evading arrest or detention February 11th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And is that prior conviction for evading true? Get this one done, then I can get to the next one. Okay. And then let me find the other one. Sorry, give me just a second. They're not in order on here, and so I'm having to find them because I think they might be under. No. There they are. Sorry, y'all. Go paperless, they said. Okay, now in cause number 24 DCCR 2220, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that's from August 24th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Speak up, please. And then finally, in cause number 25, DCCR 0324, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from January 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
Yes,
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case.
Without objection.
It's admitted in each case. Is there any evidence that Mr. Greer is not competent?
None that I've observed, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. Give me just a second to get caught up here. In cause number 26, DCCR 0150, sorry. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with a previous conviction. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2220, also find that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 25, DCCR 0324, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases.
When sentences run concurrently, it sounds lighter, but don't be fooled. 5 years is still 5 years behind bars. And that warning about becoming a habitual felon? That's not courtroom drama, that's statutory math. 1 more felony, and the rest of your life can change permanently. This is how fast decisions compound in the justice system.
All run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you should know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. In your case, it could lead to another charge that could end up making you a habitual felon. You'll end up, next time, if you do anything else and end up in felony court, you're looking at 25 to life. Okay? So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, good luck to you, sir. You can go back with the bailiff. Ms. Holmes, you have William Mallett to sentencing. Good morning. Thank you for your patience.
Judge, I have the eye cutting and your reactions, you know, whenever you
Good morning. Are you William Mallett?
Yes, ma'am.
And so Mr. Mallett was previously in court, entered a plea of guilty to obstruction or retaliation. Before we go forward, I got a pre-sentence report done and I've reviewed that. What's the status of, it shows there's a pending criminal mischief and evading arrest or detention,
So
or,
those should be under the misdemeanor.
okay,
Cases that he does still have pending, so those be taken care of in misdemeanor court.
okay, that's what I thought. I just wanted to
Yes, ma'am.
make sure we weren't looking at something else. Okay.
As far as I
So-
know, we don't have any other felony charges.
No reason not to go forward with sentencing.
Correct, Judge.
And so have both of you had an opportunity to review the pre-sentence report?
Yes,
We
Your
have,
Honor.
yes, Your Honor.
All right, any additions or corrections?
No, Your Honor.
Judge, just more of a suggestion. And I just want to make sure that his mental health issues are addressed in probation. I think
Yes.
that's going to happen. I just want to make sure I put that out there.
I will. Thank you so much for pointing it out again also. Mr. Mallett, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. I am going to recommend that Mr. Mallett be at least, it looks like it's already the recommendation that he's on the high need caseload with Spindletop. And so we're going to get you whatever help you need to be able to be successful. But it's important that you take advantage of that, okay? So if you have appointments, you have to go to them. If medicine is recommended, you need to take medicine. Whatever it is to make you able to be successful on this probation, we're going to give you those tools through probation, but you have to ask for those things, okay? Do you understand?
Yeah.
Okay,
Yes, ma'am.
all right. And so if you do everything that you're supposed to on this probation, then this is a great opportunity because you don't have a felony conviction. At the end of the probation period, if you're successful, the case will be dismissed. You'll never be a felony, have a conviction on your record. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court. You could be found guilty of the offense, and you could go to prison for between 2 years and up to 10 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just go back with the bailiff, probation will talk to you today to give you your instructions so that you know what to do when you're released from jail, okay? And then I don't know if he has bonded out on those. Maybe you guys can request that he get those taken care of this on their jail runs this week.
Okay, I'll check to see if if they have them on the docket.
Okay.
If not, I'll,